Hello, everyone. This is Tom Fox back again with Jonathan Wilson for another breaking news podcast. Jonathan, I was thinking about this before we went on air, and I have never had a situation where I've had one individual come back to talk so many times in such a compressed time frame. And of course, we're here to talk about the machinations under the Corporate Transparency Act in the judiciary. So we're recording this on President's Day. Where are we today?
Where we are today is not too different from where we were the last time we spoke. At the moment, the Corporate Transparency Act is still not in effect by virtue of a preliminary injunction issued by a court in the Eastern District of Texas. This time, the court that's involved is Judge Kernodle's court in a case called Smith versus Treasury. The injunction is slightly different from the injunction we had in the Texas Top case. In Judge Kernodle's case, or the Smith case, the plaintiff is an individual, Samantha Smith, who wants to be relieved of the obligation to file her BOI report. So she sues the Treasury Department, saying, among other things, that the CTA was outside of Congress's authority under the Commerce Clause. In the court's order, about 2 or 3 weeks ago, the court granted an injunction as to Samantha Smith, but then separately said that the way that the FinCEN, the Treasury Department, had adopted its regulations amounted to a violation of the Administrative Procedures Act, and therefore the court was inclined to issue a nationwide injunction, a universal injunction, against any enforcement of the CTA for so long as its appeal was pending. Now, that opinion from Judge Kernodle came out, I'm thinking now it was January the 7th. Subsequent to that opinion, the Supreme Court gave us their per curiam opinion in the other injunction case, which was Texas Top Cop Shop. The Supreme Court decision in that case dissolved the preliminary injunction in that case, and then basically sent it back to the Fifth Circuit to get resolved on appeal. And that's where it currently stands. One of the questions is, when the Supreme Court acted in the Texas Top Cop Shop case by dissolving the preliminary injunction in that case, does its rationale, does its reasoning apply to the injunction in the Smith case, now in front of Judge Kernodle? So about a week ago, the Treasury Department, once Secretary Bessent was installed, made a motion in front of Judge Kernodle saying, in light of the Supreme Court's action in its case, Your Honor should dissolve the injunction you have issued in this case. And the more recent development is that on Friday, we had a filing from the plaintiffs in the Smith case, responding to the government's motion for a stay, as well as an amicus brief filed by the National Federation of Independent Business, also opposing any stay of the injunction. So that's where things stand today.
With that, however, we have had other developments, specifically including a Maine case that you've looked at, and there the district court judge in an order upheld, or at least declined to issue an injunction. But the court went on, I thought, to give some very interesting analysis on some of the claims, particularly around the Commerce Clause. And I was wondering if you might be able to sort of tell us a little bit about that case, because we now have two cases where courts have discussed the Commerce Clause. And the other one, of course, was National Small Business in the Northern District of Alabama, where the court did not issue a universal injunction, only gave an injunction to the named party. So could you tell us about that case and your sort of views on the court's analysis?
That's right. There are now several federal district courts that have ruled in favor of the constitutionality of the CTA, specifically looking at the Commerce Clause. And I thought that the Boyle decision, which came out of the District of Maine, was especially persuasive. And what the judge said in that order, which was on cross motions for summary judgment, was that the Corporate Transparency Act was constitutional, and that it was within Congress's power under the Commerce Clause, because the question is not so much whether the activity, the act of forming a corporation, is an act itself in interstate commerce. We all know from law school that there are many Supreme Court cases upholding the exercise of congressional authority under the Commerce Clause in situations where the activity was purely intrastate, but it had the cumulative effect of having an impact on interstate commerce. And that was the analysis that the judge applied in the Boyle decision. What the judge said was that here, the Corporate Transparency Act applies, when a person forms a corporation or an LLC. The act of forming the corporation or LLC is not in and of itself an act in interstate commerce. But the judge ruled the act of forming a corporation is something that in the aggregate has an impact on interstate commerce. Corporations and LLCs are the primary instrument through which people organize businesses in order to engage in interstate commerce. Therefore, because the aggregate effect of all those corporate formations has an impact on interstate commerce, Congress was within its power to regulate that activity through the Corporate Transparency Act. And that was the rationale that I think the judge in the Boyle case articulated very well. And so taking it back to Texas now, will Judge Kernodle in the Smith case perhaps have some additional food for thought when that judge considers whether he ought to change his perspective and perhaps reverse himself in the injunction he issued in the Smith case.
So procedurally, is that where we are, that the parties have gone back to Judge Kernodle in the Eastern District of Texas district court case and ask him to withdraw the nationwide injunction and certainly, or perhaps allow an injunction on the named party if he was so inclined? Or is that appeal at the Supreme Court now?
That is now in front of the Eastern District of Texas. So the Department of Justice, the Treasury Department, has made a motion in the Eastern District of Texas for Judge Kernodle to dissolve or to stay the preliminary injunction. The plaintiffs in that case have disagreed with that. And then there's been one amicus party that has filed a brief in favor of the plaintiffs, asking for the injunction to remain in place. I suppose there are several different ways that Judge Kernodle could go. If Judge Kernodle remains convinced that the law itself was unconstitutional under the Commerce Clause analysis, he might modify the injunction so that it only involves the named plaintiffs, since the second half of his opinion that dealt with the Administrative Procedures Act was sort of tacked on a little bit. It was outside of what the plaintiffs had asked for in that particular case.
And any ideas on where we are currently with the Supreme Court, or was the Supreme Court lifting of the nationwide stay the end of their actions until these cases work their way up through the courts of appeal?
At the moment, there is nothing that's in front of the Supreme Court. We have Judge Kernodle's case, the Eastern District of Texas. We have the appeal that is in front of the Fifth Circuit in the Texas Top Cop Shop case. I have to say that one very slowly every time I say it. And that oral argument had been scheduled for March 25. It has now been pushed off until April 1. And we're still waiting for the 11th Circuit. My colleagues here from just a few miles away in downtown Atlanta, that particular case had oral argument back in September, and we are now a solid 5 months beyond that date, and we're still waiting for an order. I checked Pacer this morning, and by 9 a.m., it still hadn't yet come out. Now, I think there's also going to be an appeal in the Fourth Circuit Court of Appeals. That is in the Community Associations Institute case. That was another one where court in the Eastern District of Virginia came down in favor of the constitutionality of the case. And I would expect the CAI would appeal to the Fourth Circuit. And to be honest, I have not checked the docket there recently.
Jonathan, I want to publicly thank you because I get contacted a lot on this issue, and they always ask, do you know Jonathan Wilson? And your outreach on this issue has just been outstanding. You continually update us on LinkedIn to let us know the current rulings. You truly are a subject matter expert, not just on the CTA, but for procedure and constitutional claims. It's been a pleasure working with you on this. And I know we're going to continue this conversation, and I'm just going to say, keep up the great work.
I appreciate it, Tom. Thank you so much. Thanks for having me.
But before we leave, if anyone wanted to reach out directly to you or get more information, where should they go?
I am easy to find. You could always DM me on LinkedIn, or if you want to email me, you can find me at info@fincenreport.com.
And I will just say some of Jonathan's competitors DM me on LinkedIn and ask if I know Jonathan. That's how well respected he is in this field. So keep up the great work, Jonathan.
Don't be shy. Just reach out. Thanks, Tom.